After you've signed the will and the powers of attorney in front of a notary, everything's all formal and legal, the question often comes up, can you change an estate plan? And the answer is almost always yes, you can. As long as you have the cognitive capacity to make decisions, then you may change your estate plan, and you may very well want to change your estate plan if there's been changes in your circumstances. So I can think of at least 3 circumstances where you do want to change your estate plan. My name is Patrick Cawley. I'm with Keystone Elder Law in Mechanicsburg, Pennsylvania. And these are the 3 most common scenarios that I've encountered where people very much should update their estate plan. The first deals with a change in the family. So whether it's an old beef with a family member and you're letting bygones be bygones, that's a reason why you might want to bring that person back into being a part of your estate plan. Maybe there have been grandchildren born. That's a happy development. Or maybe people have passed away. If you were leaving gifts to grandchildren, you don't want anybody to be excluded. And if you are relying on certain family members to be your decision makers, perhaps in a power of attorney, in the event that you become incapacitated, then you may need to update your estate plan. So any of these changes in family circumstances may be a good reason to update your estate plan. The second has to do with disability or perhaps long-term care. So if your spouse goes into a nursing home and Medicaid is paying for long-term care, you definitely want to update your will if your will currently says, I leave everything to my spouse when I pass away, because Medicaid says you're not allowed to have a lot of money. So if that money comes pouring in, you will eliminate Medicaid to pay for long-term care. That's a mess you want to avoid by updating your estate plan. Same goes for a child or grandchild with special needs or a disability. If you have a child or grandchild who relies on Medicaid or SSI to pay for the necessities of life, do not leave money to that person or give during your life to that person outright, because it will eliminate the benefits. And the final situation in which you probably do want to update your estate plan is if you have a change in your finances. So we've talked about the change in family, we've talked about a disability or long-term care, but what if you have a change in your finances? So say you have 3 children and your plan is to leave all of your property in 3 equal shares, so everything's fair, but you have a change in how you hold your property. Only some property goes through the will. The house, perhaps a bank account, anything that's titled in your name will go through your will. But what if you no longer have the property that would go through your will and everything's tied up in a retirement account or a life insurance policy, or some designation on an account that says, when I'm gone, here are the beneficiaries I designate to get this money. If it's no longer held in a way that your estate plan will go according to how you have divided it for 3 people, then you need to come up with a new plan to make everything fair. Maybe that involves changing your beneficiary designations. Maybe it involves changing your will. But anytime you have a change, you no longer own certain property, you have to remember, did I leave that property in my will? And have I now cut out the person I thought was going to get that? So if you had a plan for equal distribution and you have a change in how you hold your property, that's a reason to update your estate plan as well. If you have any questions about this, if you need some guidance to think through how things have been set up and what the change in circumstance may be, send me an email at info@keystoneelderlaw.com or give us a call, 717-697-3223.